Every day in the USA, people find themselves in court.
Let's go with the 9:30 docket and see what's ready to go. Langston,
Yes,
Lindsay Maynard.
Yes, he has been evaluated already, I believe. Let me get him out.
Thanks.
Well, yeah.
You're not sure he's been evaluated? You want to get him out here?
No, he has been.
Oh.
He's been evaluated.
What are we gonna, what's an announcement?
He is adamant that he does not want any plea deals.
Please, presumed innocent. That gun?
Yes.
May 30th is what I have.
Yeah, I got it too. Your bonds report. Here you go.
Here it comes. You're Lindsay Maynard.
Yes, sir.
In cause number 24 CR 1913, sir. Mr. Adams is here representing you, and you were charged with a third-degree felony of assault on EMS personnel, which, as you know, carries with it up to 10 years in prison if convicted. There is a recent report prepared by Dr. Edgar Pond upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Ed Lapon. I am calling these course exhibit number 1 in this court today's date. Any objections?
No.
This would be made a part of the record. Sealed and
But it's been a while since I looked at it. Does it evaluate only competency?
take your dance. And May 30th. Dr. Edgar Pond not only reaffirmed his earlier analysis of competence, but went into the issue of sanity or insanity. Do you think that's going to be? Very good questions. I think he thinks out there is going to be fine. Yeah. Fine. Right. Can you get a copy of this May 30th report?
I got this one.
That's 21, yeah. And then Dr. Dupont went on to pick up the issue of sanity or insanity on his 30th day report. Okay. How about this one?
What's the good doctor's opinion about that second issue?
Okay. It's we got this some competing issues is that the defendant is brought to the hospital with what is reported as a drug overdose in an attempted suicide. And he wakes from sedation in disoriented state, and attempted to remove the breathing tube, kick the nurse who was trying to assist him, which is, I think, where the assault occurred.
Yes, sir.
His version is the defendant states he doesn't remember. His diagnosis is delirium, which is now long resolved. Now, delirium in psychoanalysis is a state of mental confusion and reduced awareness characterized by sudden onset of symptoms consistent with confusion, disorientation, and difficulty thinking clearly. It is a serious but treatable condition characterized by sudden change of mental state, including confusion, disorientation, and reduced awareness. Any delirium is a serious disturbance in mental ability that results in confused thinking and reduced awareness of one's surroundings. And it is obvious in this case, the man was suffering from an obvious delirium. He goes on to state that the determination of sanity or insanity is the province of the trier of fact. And the problem we have here is we got some competing interests. He's suffering under what Dr. Edward Pond calls confusion, delirium, but it's from overdose of drugs, which is not an excuse. You can't overdose on drugs and then start claiming defenses. So
it sounds like he's
fact finder to make a decision
right.
on these competing interests. But it's, I think everybody would see, can see if somebody is is misusing drugs and then is being treated and starts beating up the medical personnel. We got problems. Medical personnel to be protected, and there is the issue of the patient if they are in a reasonable state of mental awareness. But if they are not, because of their volitional misuse of drugs, that's not a defense. That's for, I guess, a fact finder to listen and weigh and make a decision over. But you can't say I'm going to misuse drugs and then later harm personnel who are trying to treat you.
So
if that were allowed, I think most people would say who show up to treat or to take care of someone, and then they find out that this is a misuse of drugs, then why would they want to put themselves in harm's way? Because they can be harmed and then there's no accountability for it. That's not, well, that it does not seem to be a social standard that we want to go down. Yeah, people need to be treated when they're not well, but the treating authorities should not be left without any type of defense under law. And otherwise, people are going, the ambulance aren't going to start showing up at locations if they find out that it's drug overdose. It'll get out pretty quick. But they've got other things to do that are more important than self-harm. So that's what it states. And it's a fact is for the a fact finder. You want to go to the judge or the jury, that's your call, but it's a possible defense that can be raised, but it's not for, it's for the fact finder to decide, and he's competent otherwise. So set it for trial.
But have you been able to talk to him about the offer or?
I have.
Okay.
Yeah, I've given him the offer of, the last offer we got was a cap of 8 years. I did get that to him and
All right, you told it to him. It's his decision. It's set for trial, and we'll let a jury roll it out. And
He has a lengthy criminal history and is not probation eligible.
anything else? You understand where we are, sir?
Yes, the
Okay.
attorney said, yes,
Anything else you want to add, sir? No, just
my power of attorney was not notified that this was happening today, and I'm trying to get my attorney to call my power of attorney, my caretaker, to be here. I have traumatic brain injury and seizures. I've been in the hospital all day yesterday and tonight, and I was missing this court date last time because of having seizures in the hospital. But I need my caretaker here.
We'll subpoena those records.
okay. Anything else? Is set for trial. Thank you.
Thanks.
Next is, let's.
Thank you.
Yes, sir. Don?
yes,
Michael Aguirre?
yes, please need to bring
Come on up.